Welcome back to Revenge Room. Today's story is titled, I Refused My Son $200K for a Car. He sued me for $500K. The court's verdict shocked him. Imagine spending your entire life building something from nothing. 40 years of early mornings, late nights, sacrifices your family never saw and never asked about. You built a business. You built a home. You built a legacy. And you did it quietly, with discipline, with dignity. Then one afternoon your son and his wife walk through your front door, not to visit, not to check in, but to tell you with a smile that doesn't quite reach their eyes that it is time for you to start writing checks. A $200,000 luxury car, money toward a mortgage on a house you never co-signed, and the words that will stay with you long after they leave. Dad, you've saved enough. It's time to help your family. You say no, calmly, firmly, the way a man says no when he has already seen this moment coming from a mile away. 2 weeks later, a legal envelope arrives at your door. Inside it, a lawsuit, $500,000, filed by your own son, signed with his name, but written every word of it in someone else's handwriting. What they did not know, what they never thought to ask, is that this old man had been watching and waiting and preparing long before they ever walked through that door. And when this case finally reached a courtroom, the judge said something that stopped the room cold. Stay with me until the end of this story, because what happened next did not just change one family, it revealed exactly what happens when the wrong people underestimate the right one. My name is Leon Grayson. I am 71 years old, a widower and a retired founder of a logistics company I built from a single leased truck and a borrowed phone line into something that employed over 200 people before I sold it. I did not retire because I ran out of energy. I retired because I had finished what I set out to do, and I have never believed in staying past the end of a thing. I have lived alone in my Columbus home for 9 years, since the morning Margaret died in the room down the hall with her hand in mine, and her breathing gone so quietly that I did not realize for a moment that she had left. The house is the same house we bought together 34 years ago. I have not changed much about it. Her reading chair is still in the corner of the living room. Her garden is still in the backyard, though I tend it now imperfectly, the way a man tends something that was never quite his, but that he refuses to let disappear. People have suggested gently that I sell and find somewhere smaller, somewhere newer. I have no interest in that. This house is not a burden to me. It is a record, and I am not finished reading it. I want to be clear about something before I tell you what happened. I am not a sentimental man. I loved my wife deeply, I love my son, and I am capable of warmth when warmth is what a moment calls for. But I spent 40 years reading people across negotiating tables in rooms where everyone in the room was pretending to want something different from what they actually wanted. You do that long enough, you stop confusing what people say with what people mean. You learn to watch the eyes before you listen to the words. It is not cynicism. It is a survival skill that served me very well in business, and it has served me even better in what came after. My son Caleb is 41. He works in technology management, makes a respectable living, and has been married to Isabella for 9 years, the same 9 years I have been alone. As it happens, though I have never said that out loud, and I do not say it now with any particular meaning. Isabella is a wealth manager. She is 38 years old, and she is the kind of woman who enters a room and immediately understands its geometry, who has power where the exits are, what everything is worth. I noticed that about her from the beginning. I considered it a professional quality. I was not wrong about what it was. I was only wrong about where it would be directed. They arrived on a Saturday afternoon in early spring. Caleb called ahead, which he always does, and I made coffee, which I always do, and we sat in the living room the way families sit when they are about to have a conversation that has been rehearsed on one side and not the other. Isabella was warm. She asked about the garden. She complimented the light in the room. And then, with the ease of someone who has practiced the pivot, she moved into the reason they had come. The car was a $200,000 vehicle she described as a family investment. Something about image, something about the neighborhood they had moved into, something about how certain things signal the kind of success that opens doors professionally. Caleb nodded at the right moments. I watched him do it and noticed that his eyes did not move the way a man's eyes move when he is saying something he believes. They move the way a man's eyes move when he has agreed to deliver a message and is monitoring how it is being received. I declined. I did not raise my voice. I did not explain myself at length because I have found that lengthy explanations are a form of apology, and I had nothing to apologize for. I simply said that it was not something I would be doing, and I meant it without cruelty or drama. What I did not say, what I made no sign of noticing, was that Isabella had spent the previous 20 minutes asking me questions that had nothing to do with a car. She asked how my estate planning was structured. She asked whether my assets were liquid or held in trust. She asked with a smile whether I had ever considered simplifying my financial arrangements now that I was older and living alone. She framed every question as concern. I received every question as data. That evening after they left, I picked up my phone. I pressed record before I set it on the table. And then I called Patrick Donovan, my estate attorney, and I told him that I thought it was time we reviewed the trust documentation together. Patrick asked if something had happened. I said not yet. I said I wanted to be ready when it did. I looked at Margaret's photograph on the sideboard before I went to bed. I remembered something she had said to me 9 years ago in the first year after Caleb's wedding, said once and never repeated. She looks at this house the way someone looks at something they're deciding whether to buy. I had filed it away the way I file everything, quietly, completely, without forgetting. Margaret had a gift for seeing clearly without needing to be cruel about what she saw. I think about that often. 2 weeks after that Saturday afternoon, a legal envelope arrived at my front door. I opened it at the kitchen table with my coffee, the way I open everything without rushing. The number on the lawsuit was not $200,000. It was $500,000. And the name on the filing was my son's. I have read a great many documents in my life. Contracts, acquisition agreements, settlement terms, letters from attorneys written in the particular language attorneys use when they want to sound precise, while leaving everything slightly open. I know how to read what is written, and I know how to read what is not. The lawsuit that arrived at my door was both things at once. A document that said one thing on its surface and meant something else entirely underneath. And it took Patrick Donovan approximately 40 minutes to show me the full architecture of it. Patrick has been my attorney for 16 years. He is 64 years old, deliberate in the way that only people who have seen genuinely bad outcomes can be deliberate, and he does not soften things for the sake of my comfort. That is why I chose him, and that quality served me well on the morning he sat across from me in his office with the lawsuit on the desk between us and walked me through what it actually was. The filing claimed verbal contract and something called detrimental reliance. The theory, Patrick explained, was this: Isabella had placed a deposit on the vehicle using her own personal funds, and she was now arguing that she had done so in direct reliance on a promise I had allegedly made. A promise. The document suggested that any reasonable person in her position would have acted upon. Under Ohio law, he told me, verbal promises are generally unenforceable for transactions of this size, but detrimental reliance creates a narrow exception. If someone acts in good faith on a promise and suffers a financial loss as a result, a court can, in certain circumstances, hold the person who made the promise accountable. The $500,000 figure was not an accident, and it was not ambition for its own sake. It included the car, a category labeled emotional damages, projected legal costs, and enough additional inflation to make the number feel insurmountable to a person who might prefer to settle quietly rather than fight publicly. It was a pressure number. It was designed to make me want the whole thing to go away. I told Patrick I understood that part. I asked him what he was not telling me yet. He looked at me over his reading glasses and said that the lawsuit itself was probably not the goal. It was the door. He set a second document on the desk beside the first and explained what Isabella's legal team was positioning for. The real strategy, layered beneath the detrimental reliance claim, was to use the court proceedings to introduce an argument of undue influence. The claim would be that I had not been acting with full mental and emotional independence when I created the irrevocable trust several years ago, that I had been manipulated, pressured, or diminished in some way that rendered the trust invalid. If a court were persuaded by that argument, the trust could be voided, not reduced, not modified, voided entirely. And if the trust were voided, the assets held inside it would revert to my estate in a form that could be legally contested, divided, and claimed. She was not coming for $500,000. She was using $500,000 as a crowbar to try to open something worth considerably more. I sat with that for a moment. Then I told Patrick to continue. He told me the good news, which was that the trust documentation was strong. I had established it with full legal formality, 2 independent witnesses, and a signed attestation of mental competency from my physician at the time, who was not a man anyone could characterize as easily pressured. The paper trail was clean and complete. An undue influence argument, Patrick said, would face serious evidentiary obstacles. He was not dismissing the threat, but he was telling me clearly that Isabella had chosen a strategy with a low probability of success, which meant she was either more desperate than she appeared, or she was counting on something other than winning the legal argument. She may have been counting on the process itself being unpleasant enough that I would choose to make it stop. She had miscalculated that. The mediation session was held 3 weeks later in a conference room on the 14th floor of a building downtown. Isabella arrived composed, dressed in the way she always dressed, precise, deliberate, projecting the appearance of someone who had already decided how the meeting would end. Caleb sat beside her. He sat there the entire morning and he did not look at me. Not once. I want to be clear about what I mean when I say that, because there is a difference between a man who cannot bring himself to meet his father's eyes out of shame and a man who has made a decision not to. Shame moves. It flickers, it surfaces, it tries to hide itself, and fails. What I saw in my son that morning was not shame. He was still. He was contained. He answered questions when he was spoken to, and he said nothing when he was not. And the whole time he kept his gaze carefully away from mine, the way a person keeps their gaze away from something they have already processed and filed and decided to move past. He was not surprised by any of it. He was managing himself. That is a different thing entirely, and I recognized it because I have done it myself in rooms where the outcome was already decided, and the only remaining question was how to hold your expression while the other side caught up to what you already knew. We left the mediation without resolution. Patrick drove. We rode in silence for several minutes, the way 2 people ride in silence when they are both thinking about the same thing and neither of them needs to say it out loud. Then I said it out loud anyway because I wanted to hear how it sounded when spoken in daylight. I said this was never about a car, Patrick. So what exactly are we protecting, and what does she think she has already won? Patrick kept his eyes on the road. He did not answer right away. That told me he had already been asking himself the same question. There is a particular kind of clarity that comes the morning after a long and unpleasant thing. Not relief exactly, and not resolution, but a kind of settling the way sediment settles to the bottom of a glass once you stop shaking it. I drove home from the mediation with Patrick's question still hanging in the air between us, and I slept that night, the way I have trained myself to sleep since Margaret died, without assistance, without distraction, and without leaving. Problems unexamined at the threshold of the bedroom door. I had been building toward this moment longer than Isabella knew. The question was never whether I was prepared. The question was how much of that preparation I was willing to show, and when. Patrick called me 2 days after the mediation and asked me to come to his office. I told him I had something to bring him. He said he suspected as much. I set my phone on his desk and played the recording. Patrick listened without interrupting, which is one of the qualities I value most in him. He listened to the whole of it, the pleasantries, the pivot, the pitch about the car, and then he listened to what came after the pitch, which is the part that mattered. He listened to Isabella ask me in a tone calibrated to sound casual whether my trust assets were liquid or structured. He listened to her ask whether I had considered simplifying my financial arrangements. He listened to her use the phrase trust flexibility twice in the span of 4 minutes, and he listened to her say with the warmth of someone offering a gift, rather than extracting information that I had saved enough that it was time to help. My family. When the recording ended, Patrick sat back in his chair and looked at the ceiling for a moment. Then he looked at me. He told me that under Ohio's one-party consent law, the recording was entirely legal. I had been a participant in the conversation. I had recorded it on my own device, and I had done so in my own home. There was nothing inadmissible about it, nothing that could be challenged on procedural grounds. He was careful to tell me that the recording alone would not decide the case. Courts do not convict on tone and implication, but what it established clearly, and in Isabella's own words, was a pattern of premeditated inquiry into my financial architecture on the very day she arrived to make a request she had every reason to believe I would refuse. It established intent, it established premeditation, and it established that the questions she asked were not the questions of a daughter-in-law making conversation. They were the questions of a person conducting an assessment. I told Patrick I had made the recording that evening because something in the afternoon had felt wrong in a specific way. Not emotionally wrong, not the vague discomfort of a difficult family visit, but professionally wrong the way a meeting feels wrong when you realize the agenda that was sent to you is not the agenda being run. I have felt that feeling in enough conference rooms to trust it immediately. I did not know exactly what Isabella was planning when I pressed record. But I knew she was planning something, and I knew that the version of events she would later describe would not match the version that had actually occurred, and I wanted a record that could not be edited after the fact. Patrick nodded and moved on because there was more to cover, and he is not a man who wastes time on what has already been established. We spent the next hour going through the trust itself, its origins, its structure, and the documentation that surrounded its creation. I had established the irrevocable trust 3 years ago when I was 68 years old and in full health with a clarity of purpose I had never doubted for a moment. Patrick had handled the legal construction of it, but the decisions about what to include and how to structure it had been mine entirely. 2 independent witnesses had been present at the signing, neither of them people with any financial interest in my estate, both of them with clear and documented memories of the occasion. My physician at the time had signed a written attestation of my mental competency, a step I had requested not because anyone required it, but because I had read enough estate litigation to know that documentation is the difference between a clean outcome and a complicated one. The timestamps on every document were precise and unambiguous. The paper trail did not have gaps. For Isabella to succeed with an undue influence argument, she would need to convince a court that I, a man who had spent 4 decades negotiating complex commercial agreements, who had sold a company and managed its transition without a single legal dispute, who had structured an irrevocable trust with the methodical care of someone who understood exactly what he was doing, had somehow been coerced or mentally diminished at the age of 68. Patrick looked at the documentation spread across his desk and said with the quiet confidence of a man who has won and lost enough cases to know the difference that it was among the cleanest trust constructions he had seen in 30 years of practice. It was not a boast. It was a professional assessment delivered without flourish. I asked him what Isabella was actually counting on, if not the legal argument. He said she was counting on the process. Litigation is expensive, public, and exhausting. Most people, he told me, settle not because the other side is right, but because continuing to fight costs more than they are willing to pay in money, in energy, in the exposure of private family matters to public record. She had calculated, Patrick believed, that I was a 71-year-old widower who would prefer a quiet resolution to the spectacle of a trial. She had priced my dignity and decided she could afford it. I told Patrick that she had mistaken caution for weakness and that I intended to show her the difference. He allowed himself something that was almost a smile. Then he told me he wanted to reach out to someone, a woman named Joanne Fletcher, who had been Margaret's closest friend for 30 years. He said he had a feeling, the kind of feeling he had learned not to dismiss, that Margaret's early years with Isabella might matter more than either of us currently understood. He did not explain further, and I did not press him. I simply told him to make the call. That evening, Patrick's financial investigator sent over a preliminary report on the broader family finances. I was reviewing it with a cup of coffee when Patrick called. His voice had the particular quality it takes on when he has found something he was not looking for. He told me that Caleb had recently refinanced his home. A significant refinance, larger than his income profile would suggest, was routine, and that a substantial portion of the proceeds had been transferred into an investment fund. A fund Patrick had never encountered before, connected to a firm he could not immediately identify. He said he was going to need a few days to trace it properly. I told him to take whatever time he needed. I set the phone down and sat with my coffee and thought about my son's face. At the mediation still contained the face of a man managing something he had already decided to carry, and I wondered for the first time exactly how long he had been carrying it. Patrick is not a man who uses the phrase "I need a few days" loosely. When he says it, he means he has already found something and wants to be certain of its dimensions before he describes it to you. I have known him long enough to understand that the interval between a discovery and his report of it is not delay, it is precision. So I waited, and I tended the garden, and I did what I have done every morning for 9 years, which is move through the house with the disciplined quiet of a man who has made peace with stillness even when his mind is not still at all. He called on the 4th day. He asked me to come in. When I arrived, there were 2 documents on his desk and a printed spreadsheet beside them, and the expression on his face was the one he wears when the news is worse than he hoped but not worse than he feared. The investment fund, he told me, belonged to Isabella's wealth management firm, not a separate personal venture, but a fund she managed directly, and for which she bore professional and fiduciary responsibility. Over the previous 18 months, it had lost 34% of its value. The losses were the result of high-risk positions that had not been disclosed to investors with the specificity the law required, and the fund's current valuation was approaching a threshold that would trigger mandatory reporting obligations to the Securities and Exchange Commission. Once that threshold was crossed, Isabella would be required by law to disclose the losses formally, at which point a license review became not a possibility but a near certainty. She was not simply managing a bad investment. She was standing at the edge of a professional collapse that would erase everything she had built, her firm, her credentials, her reputation in the financial community she had spent her career cultivating. The lawsuit against me, Patrick said, was not the action of a greedy woman looking for an opportunity. It was the action of a desperate one looking for a lifeline. I asked about the refinance. Patrick told me what his investigator had confirmed: the proceeds from Caleb's home refinance had been moved in a structured series of transfers into the failing fund. The transfers were documented. The paperwork Caleb had signed was real. But Patrick's reading of the sequence suggested that Caleb had been shown a version of the transaction that described it differently from what it actually was, presented most likely as an investment opportunity rather than a rescue operation for a fund already in serious distress. Whether Caleb had asked enough questions to understand what he was truly signing was something Patrick could not yet determine. What he could determine was the consequence: Caleb's house was not simply collateral on a refinanced mortgage. It was now financially entangled with a fund that was deteriorating, and if that fund collapsed publicly before anything could be done to contain the damage, the house would follow it down. My son had not simply been used as a legal instrument. His home, his stability, and his financial future had been quietly placed into the machinery of his wife's crisis without his full understanding of what he was agreeing to. I sat with that for a moment. I thought about Caleb at 22, just starting out, the way he used to call me on Sunday evenings to talk through problems he didn't want to admit were problems. I thought about how that had changed gradually and then completely, and I had told myself it was the natural distance that grows between a father and a grown son. I was not certain anymore that distance was the right word for what had happened. Then I told Patrick about the estate adjustment documents. A year before the car conversation, so approximately 2 years before the lawsuit, Isabella had brought me a set of documents she described as routine estate planning updates. She said my accountant had suggested them, which was the first thing that struck me as wrong because my accountant communicates with me directly and had said nothing of the kind. The documents, as she explained them, were designed to streamline the distribution of trust income during my lifetime. I looked at them for approximately 10 minutes. I did not sign them. I told Isabella I would have Patrick review them before I put my name to anything, and she said, "Of course, naturally, take all the time you need," and she left without pressing further. The documents were never mentioned again. I had kept my copy and forgotten about it, the way you keep things you refused, without quite understanding why. Patrick looked at his copy for a long time. Then he told me what the documents would actually have done had I signed them. They contained language that would have redirected a portion of the trust's annual income into a secondary account designated for what was described as family operational expenses. The account was not mine. Patrick traced the account number to a financial structure connected to Isabella's firm. Had I signed, she would have had a legal mechanism to draw from my trust income on a recurring basis, structured in a way that would have been difficult to immediately identify as improper. She had been building this for at least 2 years before she ever walked into my living room to ask about a car. The car was not even the beginning. It was simply the moment she decided the quiet approach had run out of time. I drove to Joanne Fletcher's house that afternoon because I needed to be somewhere that felt like the world I recognized. Joanne is 72 and has the particular warmth of a woman who has paid attention to people her entire life and found most of them worth the effort. She made coffee without asking, and we sat at her kitchen table the way people sit when they have known each other long enough to skip the part where you explain why you came. We talked about small things first. Then I mentioned Margaret, which I always do eventually because Joanne is one of the few people left who knew her the way I did, not as a memory but as a person. Joanne said something I turned over in my mind for the rest of the day. She said that Margaret had always kept certain things very close to herself, things she decided were hers to carry and no one else's. She said it gently, the way you say something that is true and also touching the edge of something larger. She did not elaborate, but I noticed that she did not change the subject quickly either. She looked at her coffee cup, she looked at the window, and she did not say anything more, which is sometimes the loudest thing a person can say. I was almost home when Patrick called. His voice had the quality it gets when he is choosing his words with exceptional care. He said he needed me to look at something. He said it was the estate adjustment document, the one I had refused to sign 14 months ago. He said he had obtained a copy from Isabella's legal files through the discovery process, and that he had placed it beside my original copy, and that the two copies were not identical. He paused, and then he said it plainly, the way Patrick always says things that cannot be softened without becoming dishonest. The signature on Isabella's copy of that document might not be mine. I have signed my name approximately 40,000 times in my life. That is not an exaggeration, it is an estimate. I arrived at once during a period when I was reviewing contracts daily and began to understand that a signature is not merely a formality, but a kind of fingerprint, as individual and consistent as the person who produces it. The angle of the initial letter, the pressure applied at the baseline, the particular way the final stroke either lifts or trails, these things do not change meaningfully over time in a person who has written their name the same way since their 20s. They are not habits, they are anatomy. The forensic handwriting examiner Patrick retained was a woman who had testified as an expert witness in federal proceedings on 11 separate occasions. She was not someone who hedged her conclusions for the comfort of the people who hired her. She examined both copies of the estate adjustment document, my original, which I had kept in a folder in my study without quite knowing why, and the copy retrieved from Isabella's legal files through the discovery process, and she delivered her findings in a written report that was 7 pages, long and unambiguous in its conclusion. The signature on Isabella's copy was not mine. It was skilled, she noted that with professional precision, because accuracy mattered more to her than reassurance, but it was measurably distinct from my authentic signature in 4 specific ways she documented, with magnified imagery, quantitative analysis. The pressure distribution was wrong. The terminal stroke on the final letter broke in the wrong direction. The angle of the capital letter differed by a consistent margin, and the spacing between the first and last name, which in my genuine signature has remained essentially unchanged for 50 years, was slightly compressed in a way that suggested someone working from a visual reference rather than from the unconscious muscle memory of a lifetime. Patrick filed a criminal complaint with the Columbus District Attorney's Office the same afternoon the report was delivered. The case, which had begun as a civil lawsuit over an alleged verbal promise, was now running on 2 parallel tracks simultaneously. The civil proceedings continued in one courtroom, moving forward under their own timeline, while a criminal fraud investigation opened on a separate track with its own investigators and its own momentum. Isabella was no longer simply a plaintiff. She was a subject. The civil hearing that followed was the first time I watched Isabella perform under genuine pressure, and I want to be honest about what I observed because I have no interest in describing her as something she was not. She was composed. Her attorney stood and characterized the discrepancy as a clerical error, a misfiling, a document mix-up, in a process that had involved many papers and several offices, and was, he suggested, easily explained by administrative confusion rather than intent. Isabella sat beside him and nodded at appropriate intervals, and looked at the judge with the expression of a person who is accustomed to being believed. She was very good at it. She had practiced it, I suspected, for a long time, but the hallway told a different story. During the recess, I was walking back from the water fountain at the far end of the corridor when I heard her voice coming from around the corner, low, controlled, stripped of its courtroom warmth. She was speaking to her legal team in the tone a person uses when they are furious and cannot afford to show it fully, and are therefore showing it in the only register left available to them. I could not make out the full content. I could make out the quality of it, a person no longer running the situation she had designed, speaking to people she held responsible for the fact that it was no longer running. It lasted perhaps 30 seconds before she heard footsteps and stopped. When she came back around the corner, the composure was restored. It was a very fast restoration. That, in its own way, told me more than the 30 seconds had. Caleb was present in the courtroom that day. He sat in the gallery rather than at the plaintiff's table, which I understood was a strategic arrangement made by Isabella's attorneys to position him as a sympathetic bystander rather than an active party. At one point during the proceedings, the name of Isabella's investment fund was introduced into the record as part of a line of questioning about the financial context of the estate documents. I watched my son when the fund's name was spoken. He did not react to the name. He reacted to the number that followed it, the figure representing the fund's current valuation. And the reaction was small and well controlled, a single tightening around the jaw that a person not watching for it would not have caught. He was not hearing the fund's name for the first time. He was hearing the number for the first time. That is a specific and important distinction, and I filed it away with the same care I file everything. After the hearing, Patrick told me he had found something during the document discovery process that required careful handling before he could show it to me. A backup file associated with Isabella's email account had surfaced during the digital review, and within it was a partially deleted thread that his team had not yet been able to fully reconstruct. He had sent it to a digital forensics firm that specialized in data recovery from deleted files. He said he did not want to speculate about the contents until the reconstruction was complete. He said, "Give me 72 hours. I told him to take what he needed. I went home. I made dinner. I sat in the kitchen and thought about my son's jaw and the number and the name, and I waited. The forensics firm called Patrick in 48 hours, not 72. He called me within the hour. His voice was careful in the way it gets when he is about to tell me something he wishes he did not have to tell me. He said the deleted emails had been fully recovered. He said they contained evidence of financial fraud, which he had expected. Then he paused and said there was something else in them, something he had not anticipated, and that it was not going to be easy for me to read. He said, "Leon, this goes further than the money." Patrick sent the recovered emails to my personal printer that evening, and I read them at the kitchen table with the same deliberate attention I have given to every document in this process, slowly, completely, without allowing the emotional weight of what I was reading to outpace my comprehension of it. I have found over the course of a long life that the moments when you most want to react quickly are precisely the moments that most require you to be still. So I was still. I read every page. And when I finished, I sat for a while with my hands flat on the table and looked at the window and thought about what it means to be studied. The first thread was the one Patrick had anticipated. It was a series of exchanges between Isabella and an outside contact whose name appeared only as initials in the recovered text, a detail the DA's investigators were already working to resolve. The substance of the correspondence was a coordinated strategy for applying legal pressure to a target described in Isabella's own phrasing as an elderly widower, living alone, likely to prioritize privacy over prolonged litigation. She had not simply decided to sue me on impulse. She had consulted, planned, and constructed a model of my probable behavior. She had considered what I valued, my quiet, my dignity, the privacy of my family's affairs, and she had priced those things. She had calculated what she believed my breaking point would be expressed at in the correspondence as a figure she expected me to offer in settlement, and built the legal strategy around reaching that number before I had time to understand that the number itself was not the destination. It was written with the clinical detachment of a business plan. I was not a person in those emails. I was a variable. That alone would have been enough. But Patrick had told me it went further than the money, and he was right. The second thread was the one I was not prepared for, which is a sentence I do not write easily because I have spent considerable effort across my life preparing for things. This thread was separate from the first, maintained in a different folder, and it concerned me in a different way entirely. Isabella had been building a file, not a legal file in the formal sense, not something with an attorney's letterhead or a court filing number, but a personal dossier assembled quietly over what appeared to be at least 14 months that documented observations about my cognitive and social behavior. There were notes about my doctor's appointments, dates, the general nature of the visits, the name of my physician's practice. There were second-hand reports passed along through intermediaries I could not immediately identify about interactions I had apparently had with neighbors, with people at the hardware store, with the man who services my furnace annually. The reports noted nothing genuinely alarming because there was nothing genuinely alarming to note. I am a man in full possession of his faculties and have been without interruption, but they had been gathered and organized with the apparent intention of constructing from the accumulation of ordinary fronds. Details a portrait of a man whose mental acuity might be questioned. The specific phrase Isabella used in one message to her outside contact was building the capacity argument as a secondary position. If the undue influence claim required reinforcement, she intended to argue that I had lacked the cognitive capacity to have created a valid trust in the first place. She had never filed it. It was not ready in the sense of being finished, but it was ready in the sense of being available, waiting in a folder for the moment she decided she needed it. I have faced many things in my life that required a response rather than a reaction. This was one of them. I closed the printed pages and placed them in a folder and wrote the date on the tab in the precise, unhurried handwriting I have used since I was 20 years old, which I found in that moment to be its own small answer to the question she had been quietly asking about me. Caleb received copies of the emails through his own attorney the following morning. I know this because he called me that evening, not through Isabella, not in the careful, managed way he had communicated with me since the lawsuit was filed, but directly from his own phone in his own voice without anyone else present. I could tell from the first word that something had shifted. He said my name. He said he needed to tell me something. He said, "Not on the phone, not yet," and then he stopped as though he had reached the edge of what he was capable of saying in that moment and found nothing on the other side of it. He hung up. It was the first time in more than a year that he had called me without Isabella beside him. I recognized what I heard in his voice because I have heard it before in business, in the years when I was navigating situations where people realized, sometimes slowly and sometimes all at once, that they had been positioned rather than included. He sounded like a man who had just seen something he could no longer unknow. I recognized it because it is a specific sound, and it is unmistakable. It is the sound a person makes when they realize they have been a prop in someone else's plan. I set the phone down and looked at Margaret's photograph for a long time. I thought about the file Isabella had kept. I thought about the clinical patience of it, the months of quiet assembly, and I thought about what it means to be known by someone who is only learning you in order to use what they learn. Then I thought about Margaret, who had known me for 40 years and had spent those years building something entirely different from a file. She had spent them building a protection I did not yet fully understand, and I had the growing sense that I was approaching the moment when I would. Patrick called me just before 10 o'clock that evening. He did not call to discuss the emails. He called because Joanne Fletcher had called him unprompted an hour earlier. He said she had been holding something for 9 years. He said she believed the time to hand it over had finally arrived. Joanne Fletcher arrived at Patrick's office on a Tuesday morning, carrying a canvas tote bag, and the particular composure of a woman who has made a decision she has been postponing for a long time and has finally stopped postponing it. She is 72 years old and has the quality that some people develop in their later years of saying exactly what she means without wasting the words that surround it. She sat down across from Patrick and me at the conference table, set the bag on the floor beside her chair, and folded her hands on the table the way a person folds their hands when they are about to say something that has been waiting inside them for longer than is comfortable. She told us she had never spoken about this to anyone outside of Margaret. She said that not as a disclaimer but as a statement of the weight of what she was carrying, so that we would understand she was not a woman who talked freely about the private confidences of people she loved, and that her presence in this room on this morning represented a departure from a promise she had kept for 9 years because she had believed until recently that keeping it was the right thing to do. In the first year of Caleb's marriage, Margaret had told Joanne something she had told no one else. She said that Isabella looked at their home the way someone looks at something they are deciding whether to take, not admiring it, assessing it. Margaret had watched her during that first holiday visit, watched the way Isabella's eyes moved through the rooms, noted what she touched, and what she asked about, and what she calculated behind the warmth of her expression, and she had understood something that she could not prove and did not know how to address without causing damage she was not willing to cause. Caleb was happy, or he appeared happy, which at the time Margaret chose to treat as the same thing because she loved her son, and she knew that a mother who names what she sees too clearly can become the thing her child spends the rest of his life defending against. So Margaret said nothing to Caleb. She said nothing to me. She carried the observation alone the way Joanne told us she carried many things, not out of weakness but out of a precise understanding of what speaking would cost, and what silence managed carefully might preserve. But she did not do nothing. 7 years ago, while she was still healthy and fully herself before the illness that came later had touched anything about the way she thought or decided, Margaret had contacted an attorney. Not Patrick. She had chosen someone specifically outside my professional circle, a woman who practiced estate law in a different part of the city, so that nothing about the process would surface in conversations that might reach me. She had gone alone on a Tuesday afternoon, and she had added a provision to her own estate trust. The language Joanne told us was something Margaret had researched carefully before the appointment, because she was not a woman who walked into legal offices without understanding what she was asking for. The provision was a no-contest clause. Its terms were specific and unambiguous. If any named beneficiary of the Margaret Grayson Trust initiated or participated in legal action against Leon Grayson in pursuit of his personal assets, that beneficiary would forfeit their inheritance rights under the trust in full. No exceptions. No discretionary review. A clean and complete forfeiture activated by the act of filing. She had never told me. Joanne said she asked Margaret at the time why she didn't. Margaret's answer was one that I have turned over in my mind many times since that morning in Patrick's office, because it is the most complete description of who she was that I have ever heard from anyone, including myself. She said she didn't want it to be a weapon Leon would feel guilty holding. She knew, Joanne said, that if I had known about the clause, I would have warned Caleb before any lawsuit was filed. I would have told him what he stood to lose. I would have given him the information as a protection, and in doing so, I would have protected him from the consequences of a choice he hadn't made yet, but that Margaret already understood he might make. She did not want me to do that. She wanted the clause to exist in the place where my instinct to shield my son could not reach it, active, valid waiting beyond the range of my particular kind of love for him. I sat very still for a long time after Joanne finished. The room was quiet in the way rooms are quiet when something true has just been said, and no one wants to be the first to place ordinary words beside it. Then I said what I said because it was the only true thing available to me in that moment. She didn't save herself from what she was afraid of, but she saved me from what I would not have been able to do alone. Joanne reached across the table and held my hand. She did not say anything. She did not need to. We sat like that for a moment that I will not attempt to measure, because some moments resist measurement. Then Patrick, who had been giving us the silence with the quiet respect of a man who understands when to wait, spoke. He spoke in the tone he uses when he is adding something to the record, rather than interrupting what came before it, careful, precise, almost a footnote. He said he had been running a background investigation on Isabella's history prior to her marriage to Caleb. He said there was a sealed civil settlement in Pennsylvania dated approximately 12 years ago involving a situation he was still working to fully reconstruct. Before she had ever met my son, he said the details were not yet complete. He said he was still pulling that thread. He said it the way you say something when you already know enough to be concerned and want the other person to know that without telling them more than you can currently stand behind. Then he looked at me across the table, and his voice did not change, but the weight behind it did. He said the clause was real. He said it was valid. He said it was fully enforceable under Ohio law, and that the moment Caleb's name appeared on that lawsuit filing the provision Margaret had written 7 years ago in a law office across the city had activated. Then he asked me the question that I had been waiting without knowing it to be asked. He said, "Are you prepared to let that happen?" I had spent the night before the hearing sitting in the kitchen with a cup of tea. I did not finish thinking about the question Patrick had asked me, and the answer I had not given him out loud. Whether I had given it to myself was a different matter. I had sat with it for hours, turning it the way you turn a stone in your hand, not to examine it exactly, but to feel its weight from every angle before you decide what to do with it. By the time the sky outside the kitchen window began to lighten, I had my answer. It was not a comfortable answer, but it was an honest one, and I have found over the course of my life that honest answers and comfortable answers are rarely the same thing, and that the distance between them is where a person's actual character lives. Patrick filed Margaret's trust document with the court that morning. He had spent the previous 2 days working with the attorney who had originally drafted it, the woman Margaret had chosen in that law office across the city 7 years ago, to produce a certified copy with full documentation of its execution, the date, the witnesses, the notarization, the chain of custody from the moment Margaret signed it to the moment Joanne had kept it in her possession. The document was clean. Its provenance was unimpeachable. Its language, when Judge Porter reviewed it in chambers before the session began, was exactly what Margaret had intended it to be: precise, unambiguous, and without any provision for discretionary interpretation. A named beneficiary who initiates or participates in legal action against Leon Grayson in pursuit of his personal assets forfeits all inheritance rights under the Margaret Grayson Trust in full. Ohio law enforces no contest clauses with consistency and without sympathy for the party who triggers them. Patrick had verified this across 3 separate case precedents. There was no angle from which the clause was vulnerable. The session began at 9 in the morning. Judge Porter is 59 years old and conducts her courtroom with the economy of someone who has heard every variety of human dispute and has lost patience for the ones that waste her time. She is not unkind. She is exact. When Patrick introduced Margaret's trust document as evidence and its provisions were read into the record, she did not react visibly because she had already read it in chambers and had already formed her assessment of it. Her expression did not change. She simply noted its admission and indicated that its implications would be addressed. Isabella's legal team moved immediately for an emergency recess. Judge Porter denied the motion without elaboration. She said the proceedings would continue. I was watching Isabella when the clause was read aloud in open court. I want to describe what I saw with accuracy because accuracy is what the moment deserves. For the entirety of this case, across every hearing, every mediation session, every hallway exchange, Isabella had maintained a composure that was, whatever else might be said about her, genuinely impressive. It was a professional composure, the kind built through years of managing other people's money and other people's crises, while projecting the steady authority of someone who is always slightly ahead of the situation. I had watched it hold under pressure. I would have expected to crack it. It held when the forgery findings were introduced. It held when the fund documentation was entered into the record. It held, or appeared to hold, through every moment of this process that she had anticipated and prepared for. She had not prepared for Margaret. The collapse was brief, a matter of seconds, perhaps less. It was not dramatic in the way collapses are sometimes dramatic. There was no audible response, no visible trembling, nothing that could be described as a scene. It was subtler, and because of that, more complete: a sudden vacancy behind the eyes, a loosening of the muscles around her mouth, the expression of a person who has just encountered the edge of a map they believed they had fully drawn and found that the territory extends beyond it into space. They never charted. She had planned for me. She had planned for Patrick. She had planned for the courts and the investigators and the forensic accountants and the digital recovery specialists. She had not planned for a woman who had been dead for 9 years and who had, in a quiet law office on a Tuesday afternoon 7 years ago, thought further ahead than Isabella had thought to look. The composure returned. It always returned with her. But it returned differently this time, assembled rather than natural, the way a thing looks when it has been put back together, rather than when it was never taken apart. I was called to the stand later in the session. The examination covered the trust's origins, the documentation of my competency at the time of its creation, and the timeline of events leading to the lawsuit. Then I was asked by Isabella's attorney whether I had ever considered informing my son of the no contest clause before the lawsuit was filed, whether I had withheld information that might have led him to make a different decision. I did not hesitate. I said that I had hoped my son would make a different choice on his own. I said that I had waited. I said that he had not. I paused, and then I said what was also true, what was perhaps the most important thing I said that day on the stand, but I also know who was doing the choosing. During the cross-examination that followed, Isabella's attorney introduced the fund's name into a line of questioning about my knowledge of family finances. I was not looking at the attorney when the name was spoken. I was looking at the gallery. Caleb was seated in the 3rd row. When the fund's name entered the record, he blinked once and looked at the table in front of him. He did not look up again for a long time. The question of when my son had first known that name was not asked aloud that day. But it was in the room, and Patrick noted it, and we both understood that it had now, in a meaningful sense, entered the record. Judge Porter closed the session at 4:15 in the afternoon. She announced that she would deliver her ruling in 48 hours. She also directed in the measured tone of someone who is not making a request that all financial documentation related to Isabella's investment fund be submitted to the court in full by 9 o'clock the following morning. She did not explain her reasoning. She did not need to. The instruction was clear, and the silence that followed it in the courtroom was the silence of people who understood exactly what it meant. The 48 hours that followed Judge Porter's instruction were not quiet hours for anyone involved in the case, though they were quiet for me in the specific way that the hours before a known outcome are quiet, not peaceful, but settled the way weather settles in the hour before. Something arrives that you have been watching approach for a long time. I went home. I slept. I made breakfast in the morning and walked through Margaret's garden and did not check my phone until Patrick called, which he did at 7:15, with the particular brevity he uses when the facts are speaking loudly enough that he does not need to add much to them. The fund documentation submitted to the court overnight had confirmed everything his investigators had suspected and then exceeded it. The record showed irregular transfers, spanning 22 months' losses that had been internally reclassified to delay their appearance in investor-facing reports, and a pattern of misrepresentation in the fund's quarterly statements that was not ambiguous or subject to interpretive debate. It was Patrick. Said the kind of documentation that made investigators work straightforward because it did not require inference, it required only reading. The Securities and Exchange Commission, which had been monitoring the firm at a low level of scrutiny for several months without formal action, reviewed the submitted materials and opened a formal investigation by mid-morning. This was a separate process from the civil proceedings and the criminal fraud case that had been running since the forgery complaint. Isabella was no longer managing a legal strategy. She was managing 3 simultaneous institutional processes, each with its own investigators, its own timeline, and its own capacity to impose consequences entirely independent of the others. The structure she had built, careful, layered, designed to move in one direction while concealing its true purpose, had become the thing that was now burying her, because every layer that investigators peeled back revealed another layer beneath it that required its own accounting. I drove to the courthouse that afternoon for the closing session before the ruling. The atmosphere on Isabella's side of the courtroom had changed in a way that required no particular skill to read. The legal team's communications with each other had acquired the clipped, minimal quality of people who are managing information rather than strategy people, who know that the situation has moved beyond the point where strategy is the relevant tool. Isabella was present. She was dressed the same way she always dressed, but she was seated differently in the way a person sits when they are no longer performing for the room and are instead simply enduring it. I found my car in the parking garage afterward and was standing beside it, keys in hand, when I heard footsteps behind me. I knew before I turned around. There are sounds a person makes when they are walking towards something they have decided to do that are different from the sounds they make when they are simply walking. Caleb crossed the distance between us and stopped a few feet away, and we stood between 2 parked cars in the cold Ohio air with the concrete and the fluorescent light and the particular silence of an enclosed space that amplifies small sounds. He did not lead with an apology. I was glad of that, because an apology at that moment would have been a performance, and we were past performances. He said he had known about the fund 8 months before the car conversation. He said he found the quarterly statements by accident on Isabella's laptop one evening when she had left it open, and he had reached across to close it, and the numbers had been there before he could choose not to see them. He said he had asked her about it, and she had told him it was a temporary position adjustment, a normal fluctuation in a high-performance portfolio, nothing that required his concern. He said he had chosen to believe her. He said it plainly without softening it into something more forgivable, and I respected him for that precision. Then he looked at the concrete floor and said the rest of it, that he had not wanted to know what it would mean if she was lying, that the cost of trusting his own instinct had seemed at the time too high to pay, that deciding not to know had felt in the moment like a manageable choice rather than a defining one. I looked at my son for a long time before I spoke. I told him that what he had described was not trust in Isabella. I told him it was fear of what trusting himself would have cost him. He did not answer. He did not argue with it, which told me he had already arrived at the same place and had simply needed to hear it said by someone else in order to know that it was real. We stood in the silence for a while. Then I told him to come to the ruling. It was not warmth in the way warmth is usually meant. But it was not nothing either, and I think we both understood the difference. Patrick called that evening with the Pennsylvania details fully assembled. The civil settlement from 12 years ago had involved a family whose patriarch had been the target of a structurally similar strategy. Legal pressure applied to a financial instrument through claims of verbal agreement and undue influence, settled quietly before it reached trial. The man at the center of that case had maintained until the settlement a professional relationship with a mid-size firm in Cincinnati. Patrick told me that Caleb had worked at that firm during his first 2 years out of college. He may have met this man in passing in the ordinary way young associates meet the professional contacts of their employers briefly, unremarkably, without any reason to remember the name. He would never have connected it. He had no reason to. But the thread was there, and Patrick had found it, and its existence said something precise and cold about the deliberateness of what Isabella had done. The next morning, Judge Porter entered the courtroom at 9 o'clock exactly. I watched her cross to the bench with the attentiveness I bring to anyone who is about to say something that matters. Patrick was seated beside me. He leaned slightly toward me without turning his head and said in a voice low enough that only I could hear it that she was not angry. He had seen hundreds of judges deliver rulings. He said it again quietly, as though making sure I understood the distinction. She was not angry. That was worse. Judge Porter had said she was not angry. Patrick had said that was worse. Standing in the courtroom that morning, watching her settle into her chair with the economy of movement that characterizes people who have spent decades in rooms where their presence commands immediate stillness, I understood what he meant. Anger is a temperature. What Judge Porter brought into that courtroom was something cooler and more final. The particular quality of a person who has reviewed everything, formed a complete opinion, and arrived to deliver it without any remaining interest in the fire. Responses it might provoke. The gallery was full in the way courtrooms are full when word has moved through legal and financial circles that a ruling is worth attending. Patrick had mentioned it the night before without elaboration, which was his way of preparing me without adding to whatever I was already carrying. I sat beside him at the respondents' table and watched Judge Porter open the folder in front of her, and did not look at Isabella's side of the room because I had decided some days earlier that I was finished reading Isabella's expressions and had nothing further to learn from them. She began with the lawsuit itself. Her voice was level and unhurried, the voice of a person who is not performing the ruling but simply delivering it the way a document is delivered, completely in order without theatrical emphasis on the parts that do not require it. The $500,000 claim, she said, failed on its foundational premise. The detrimental reliance argument required that Isabella had acted in good faith on an alleged promise, using her own resources, and had suffered a personal financial loss as a result. The financial records submitted to the court told a different story. The deposit placed on the vehicle had not come from Isabella's personal accounts. It had come from the investment fund from client money held in a fiduciary capacity, which meant Isabella had not only failed to demonstrate personal reliance but had potentially compounded her existing legal exposure by using funds she did not own to manufacture the appearance of it. The verbal promise itself, she noted, lacked the elements required for enforceability under Ohio law, regardless of the reliance question. The claim was dismissed with prejudice, which meant it could not be refiled. She moved without pause to the undue influence challenge against the irrevocable trust. Leon Grayson, she said, had established that trust at age 68, with full legal formality, independent witnesses, and a contemporaneous physician's attestation of mental competency. The documentation was in her assessment among the more thoroughly constructed trust records she had reviewed. The argument that Leon had lacked capacity or had been subject to undue influence at the time of the trust's creation was not supported by any evidence submitted to the court and was on the record before her without merit. The challenge was denied. Then she turned to Margaret's trust document, and the courtroom became very quiet in the way it becomes quiet when people understand that what is about to be said will not be reversible. The no contest clause contained in the Margaret Grayson Trust, she said, was valid, properly executed, and fully enforceable under Ohio law. Its terms were unambiguous. A named beneficiary who initiates or participates in legal action against Leon Grayson in pursuit of his personal assets forfeits their inheritance rights under the trust in full. Caleb Grayson's name appeared as plaintiff on the lawsuit filing. His signature appeared on the document. The clause, therefore, had activated at the moment of filing, and its consequence was not discretionary. She paused. She said that the court wished to note for the record that this outcome had not been engineered by Leon Grayson. He had not known of the clause's existence until it was surfaced during the proceedings. It had been authored by Margaret Grayson 7 years prior in the exercise of her full legal capacity and her complete understanding of what she was doing. The forfeiture of Caleb Grayson's inheritance rights under the trust was the direct and intended result of a decision made by a woman who was no longer alive to be questioned about it, and who, had the court observed, asked no one's non-servant permission. I did not look at Caleb. I had made that decision too. Judge Porter lifted a separate page from the folder, and I watched her eyes move across it once before she spoke. She said that the court had reviewed among the evidence submitted by the respondent's legal team documentation relating to a prior civil settlement in the state of Pennsylvania, dated approximately 12 years ago, involving conduct substantially similar to the conduct at issue in the present case. She looked up from the page. She looked at Isabella directly, with the steady, unperformed attention of a person delivering a fact rather than a judgment, though the fact was its own judgment. She said, "Miss Cross Grayson, this is not the first time you have sat at a table like this. It will, however, be the last time a court permits the strategy to go unnamed." The room was silent. Isabella opened her mouth. I watched it happen from across the room, the slight parting of the lips, the automatic preparation of a response, the search for the composure and the prepared language that had served her throughout every preceding moment of this case. She found nothing. She closed her mouth. It was in its way the most complete thing I had witnessed in 18 months of proceedings. Not her defeat exactly, but the specific moment in which she understood that the version of events she had always been able to construct around herself had run out of available material. Judge Porter's final line was brief. She said this court cannot enforce entitlement disguised as family obligation. She closed the folder. She rose. The room rose with her. I walked out of the courthouse into the October air and stood on the steps for a moment and breathed. Patrick came through the doors behind me and stood beside me, and neither of us said anything for a while because there are moments that do not require immediate commentary, and this was one of them. Then his phone rang. He looked at the screen and answered it, and I watched his face while he listened, and after a moment he lowered the phone and told me it was the DA's office. Criminal fraud charges were being filed effective today, and the SEC had frozen all accounts associated with Isabella's firm, effective immediately. He said it without emphasis, because emphasis was unnecessary. He put his phone in his pocket. We stood in the October light. I thought about Margaret. I thought about a Tuesday afternoon 7 years ago in a law office across the city, a woman who had known with the quiet certainty of someone who understood people completely exactly what she was building and exactly when it would be needed. The days after a verdict are strange in a way that nobody prepares you for. You spend months moving toward a fixed point every morning, oriented by the same destination, and then the destination arrives, and the orientation disappears, and you are left standing in ordinary time again, without the structure that urgency provides. I had expected some version of relief. What I found was quieter than that, and more complete, not the sharp release of pressure, but the gradual return of something that had been absent so long I had stopped noticing its absence. I slept without waking at 3 a.m. to review documents in my mind. I made breakfast without checking my phone first. I walked through the garden in the early light, and did not think about the case at all, which was in its own way the most significant thing that changed. The consequences for Isabella moved forward with the institutional momentum that such things acquire once they are set in motion, which is to say they moved forward without requiring anything further from me. The criminal charges, forgery, wire fraud, and investor misrepresentation had been formally filed by the DA's office in the weeks following the civil verdict, and the proceedings were now their own separate process with their own timeline, likely to stretch across years before any final resolution. Her wealth management license had been suspended by the relevant regulatory body pending the outcome of the SEC investigation and the criminal case. The firm was in receivership. A group of former clients whose losses in the fund had been documented through the discovery process and were now a matter of public record had filed a civil suit of their own that was working its way through the early stages of litigation. She was not in prison. The process does not move that quickly, and I am old enough to have made peace with the fact that institutional justice operates on its own calendar, regardless of what any individual believes the appropriate pace should be. But her professional life, the thing she had spent her career constructing with the same deliberate intelligence she had directed at my trust, was finished. The name she had built in Columbus financial circles was gone in the specific and permanent way that names go when the conduct that destroyed them becomes public record. The social architecture she had maintained, the appearances, the affiliations, the carefully projected image of competence and success, had collapsed in the way things collapse when the structure beneath them is removed. What remained was a woman facing years of legal proceedings with no license, no firm, no clients, and no remaining argument that what had happened was someone else's fault. Caleb's house sold within 6 weeks of the verdict. The refinanced loan had been collateralized against the fund, and the fund's receivership value was a fraction of what he had borrowed against it. The shortfall was not something he could absorb from his income, and so the house went. He moved into a rented apartment in a part of the city I did not know well, a quieter neighborhood, smaller scale, the kind of place a person goes when they are beginning rather than arriving. He did not contest the inheritance forfeiture. Patrick received the signed acknowledgement by mail without a cover letter, without a phone call, without any communication beyond the signature itself on the required form. I was told this factually, and received it factually because there was no other honest way to receive it. He did not disappear, Patrick confirmed through Caleb's attorney that he was employed stable managing, but he did not call. Not yet. I understood that. There are things a person needs to carry for a while before they are ready to set them down in someone else's presence, and the distance Caleb was keeping was not the managed, careful distance of the months before the verdict. It was the distance of a man doing something difficult in private, which is a different thing entirely, and one I was willing to wait for. My own days returned to their shape. I tended the garden. I had lunch with Patrick on Thursdays and with Joanne on alternating Tuesdays, and these were not consolation lunches. They were simply the continuation of relationships that had existed before the case and would exist after it, which is its own form of stability that I had come to value more than I once had. I slept well. I read in the evenings. I did not celebrate the outcome because celebration felt wrong for a situation in which the only people who had lost anything were people connected to my family, and whatever those people had done, their losses were not a source of pleasure. To me, what I felt was something more precise than satisfaction and quieter than victory. It was the feeling of a thing that had been wrong having been set right, the particular completeness of an imbalance corrected, which is not the same as happiness, but is in its own way more durable. Joanne called on a Wednesday afternoon in early autumn. She said she had one more thing that belonged to Caleb. She said Margaret had given it to her with specific instructions that it was to be held until the right moment, and that the right moment was not to be determined by calendar or convenience, but by circumstance. She said she believed the circumstances had arrived. I asked her what it was. She said she thought it was something Caleb should receive from me rather than from her, and that she would bring it to my house at the end of the week. I told her I would be home. She came on Friday. She left an envelope on my kitchen table. Margaret's handwriting was on the front Caleb's name, in the careful script she used when she was writing something she intended to last. I did not open it. It was not mine to open. 3 months after the verdict, on a Thursday evening when the rain was coming down steadily against the kitchen windows, and I was sitting with a book I had not been reading, headlights swept slowly across the front window. I recognized the arc of them, the particular approach of a car that knows the driveway that has turned into it before. I set the book down. I did not move toward the door immediately. I sat for a moment in the quiet of the house and listened to the engine stop, and then the car door, and then the footsteps on the front walk. And then I got up. He was standing on the front step in the rain without a coat, which told me something before he said a word. Caleb has always been a person who prepares his appearances, not vanity, but a kind of self-management, a habit of presenting himself in a way that gives him some control over how he is received. The man standing in my doorway had not prepared anything. He was wet from the shoulders down, his hair flattened against his forehead, and he was holding nothing, no bag, no umbrella, no object to occupy his hands. He had gotten in the car and driven here without pausing long enough to pick up a jacket, which meant the decision to come had arrived faster than the preparation for it, and he had chosen to act on the decision before he could talk himself out of it. That, I thought, was the most honest thing he had done in a long time. I stepped back from the door. He came in. I did not offer an embrace, and he did not reach for one, and the absence of it was not coldness, it was accuracy. We were not there yet, and pretending otherwise would have poisoned what we were actually there for. I took his wet jacket and hung it by the door, and he stood in the front hallway looking at the house the way a person looks at a place they have been away from long enough that returning to it requires a moment of adjustment. Then he looked at me. He asked one question. He asked whether I had planned for this to happen. I led him to the kitchen, and I sat across from him at the table where I have sat through every significant conversation of my adult life, and I told him the truth in the order that it was true. I told him I had not known about his mother's trust clause until Patrick found it during the case. I told him it was not an instrument I had created or requested or even known to look for. Margaret had made that decision 7 years ago in a law office I had never visited, with an attorney I had never met, and she had kept it from me with the same deliberate care she brought to everything she decided to carry alone. When Joanne told me what Margaret had done, I had been as surprised as anyone in that room, not by Margaret's instinct, which I recognized completely, but by the fact that she had acted on it so precisely and so quietly without ever giving me the chance to interfere. I told Caleb that I had not orchestrated the outcome of this case. I had protected my assets, yes. I had prepared, yes. I had recorded a conversation and called my attorney and built the strongest legal position I could. But the thing that had determined the final shape of the consequence, the clause, the forfeiture, the specific cost he had paid, that had been his mother's work, not mine. He was quiet for a moment. Then he asked why I had not warned him. It was a fair question, and it deserved a fair answer, and I gave him the one that was true rather than the one that was easier to hear. I told him I had not warned him because I did not know at the time whether the warning would reach him or her. I told him that what I had needed to understand what the entire preceding year and a half had in its deepest sense been about was which one of them was actually making the decisions in his life. I had watched him at the mediation and seen a man containing something he already knew. I had watched him in the courtroom and seen a man whose reactions did not match a person hearing things for the first time. I had watched him for 9 years make himself smaller in rooms where Isabella was present, and I had asked myself many times whether that smallness was love or something that had replaced it. I needed to find out, and the only way to find out was to present him with a moment that required a decision that was genuinely his, not suggested by me, not influenced by a warning I had provided, and to watch what he did with it. I told him I was sorry it had cost him this much to answer that question. I told him I had meant the apology before I finished saying it, which is not always the case with apologies, and he deserved to know the difference. But I told him I had needed to know, and I would have needed to know regardless of the cost, because there are things a father requires to understand about his son that cannot be arrived at through easier means. Caleb sat with that for a long time. He did not argue. He did not reframe it or search for a version of it that distributed the weight differently. I watched something in him settle, not relax exactly, but settle the way a structure settles when the pressure that has been working against it is finally removed and it can return to its actual shape. He looked older than 41 in that moment, and also strangely younger, the way a person looks when they have stopped performing a version of themselves and are simply sitting in a kitchen being who they are. I let the silence stand for a while. Then I stood and crossed to the sideboard where Joanne had left it on Friday, and I picked up the envelope and I walked back to the table and placed it between us. Caleb looked at it the way you look at something you are not sure you are ready to receive. His mother's handwriting was on the front, his name in the careful, deliberate script she used when she was writing something she intended to outlast the moment. He looked at it for a long time, without touching it. And then I heard him stop breathing just for a moment, the way a person stops when something reaches them in a place they had forgotten was reachable. I stood in the doorway of the kitchen long enough to give him the room, and then I walked down the hall to the study and sat in the chair I use when I am reading and I did not read. I looked at the window and listened to the house. There are sounds a house makes when someone else is in it that are different from the sounds it makes when you are alone, and after 9 years of the latter, I have become precise about the distinction. I heard the small adjustments of a person settling into stillness, the chair, the table, the particular quality of quiet that accompanies someone opening something they are not sure they can bear to read. Joanne had told me when she brought the envelope what the letter contained. She told me because Margaret had told her years ago in the same conversation in which she had given Joanne the instructions, "Wait for the right moment, not before you will know it when it comes." She told me not so that I could prepare a response, but so that I would understand what my son was sitting with alone at the kitchen table, in the house where he had grown up, reading words his mother had written 6 years ago for a moment. She had believed would eventually arrive. Margaret did not lecture in the letter. That was the first thing Joanne told me, and it was the thing that surprised me, least because lecturing was never Margaret's instrument. She was a woman who understood that the people you love cannot be argued into becoming who they need to be. They can only be seen clearly enough and with enough love that they begin to see themselves the same way. She did not mention Isabella by name. She did not reference the marriage or its difficulties or anything specific about the life Caleb had been living. She told him what she had always known about him, which was that he was not the problem. She told him he was a person who had come to believe that love required him to look away from things that frightened him, that the looking away was a form of loyalty, a form of protection, a form of devotion to the people he cared for. She told him she had watched him do it his whole life, long before Isabella, long before any of this. She told him he was not a bad man. She told him he was a frightened one. And then she told him the thing that I have turned over in my mind many times, since Joanne described it to me, because it is the most precise expression of unconditional love I have encountered in the language of ordinary words. She said she loved him for it, not despite it. And she said it was time to stop being afraid of what he already knew. I went back to the kitchen after a while. I did not announce myself or ask if he was ready. I simply came back into the room the way you come back into a room in your own home, quietly and without ceremony. Caleb was sitting with the letter in his hands, not reading it anymore. He was looking at the table. The letter was folded along its original creases and held between both hands the way a person holds something they have decided they will not put down yet. We did not speak about it directly. There was nothing to say about it that the letter had not already said, and adding words would have been a way of filling a silence that deserved to remain full. I made coffee. I set a cup in front of him and sat down across from him, and we were quiet together for a while in the way that people can be quiet together when the silence is not avoidance but accommodation, making room for something that is still, settling. Then I told him what I needed to tell him, because the letter was Margaret's truth, and what came next was mine, and they were not in conflict, but they were separate. I told him there would be no financial support, not immediately, and I did not know about eventually, but I was not going to make a promise about eventually, because eventually is a horizon that moves, and I have spent enough of my life watching people grant each other the comfort of promises they construct around distance rather than truth. I told him he was 41 years old and not broken. I told him I could see clearly that he was not broken, that a broken person does not drive through rain without a jacket to ask a question they are afraid of the answer to, and that what he needed was not something I could give him or anyone else could give him. It was something that existed only on the other side of the work he had not yet done, but was, I believed, beginning to understand he was capable of. I told him I was telling him this because I loved him, not because I did not. I said those words in that order deliberately because the sequence matters. Love is the reason, not the qualification. He received it without argument. He did not ask me to reconsider or soften it or explain it differently. He sat with it the way he had sat with what I told him earlier in the evening, with the particular stillness of a person who is absorbing something rather than deflecting it. And I thought that whatever Margaret's letter had done in the 20 minutes he had spent alone with it, it had done something real. We sat together until well past midnight. I did not ask him to leave, and he did not move to go, and the time passed in the way time passes when two people are not performing for each other, slowly without urgency, punctuated by ordinary small things, a refilled cup, the rain easing, outside. I did not embrace him when he finally stood to go. We were not there yet, and I did not intend to pretend otherwise. But I walked with him to the door, and I stood in the doorway while he put on his still damp jacket. He paused on the front step. He asked in the voice of someone who has used up most of their courage for the evening and is spending the last of it on a single question, whether it might be possible to come back sometime. Not for anything specific, just to come back. His voice was quiet and uncertain in a way that was entirely unmanaged, and it was without question the most honest thing I had heard from him in years. I watched his taillights move down the wet street until they were gone. I stood in the open doorway for a moment with the cold coming in, and the rain smell, and the dark. I did not answer him that night, But I thought about the question every day for the next 365 days. A year is a specific thing, not a metaphor, not an approximation. 365 mornings that arrive without consulting your readiness for them, each one requiring the same basic set of decisions about who you intend to be before the day has given you any information to work with. I have lived enough years to know that the ones that change you rarely feel transformative while they are happening. They feel like ordinary time, and then you look back and understand that ordinary time was the mechanism, that the accumulation of unremarkable days is how a person becomes someone different from who they were, without ceremony, without announcement, one morning at a time. Caleb told me about the logistics firm himself on one of the Sundays that had become, over the course of the year, a quiet and unscheduled habit between us. He had found the position through a recruiter and had taken it knowing exactly what it represented, a step sideways in title, a reduction in the kind of visibility that had once mattered to him, and an increase in the kind of accountability that requires a person to own their results without the insulation of a structure that absorbs mistakes before they become visible. He told me he had chosen it on purpose. He said it in a way that was not self-congratulatory but simply factual, the way a person describes a decision they have made peace with. He was attending therapy twice a month, which he had also told me without my asking, and I had received that information the way it was offered, as a fact about how he was taking care of himself, not as a confession requiring a response. The divorce had been finalized 6 months after the verdict. There had been no contest, because there was nothing left to contest, no shared assets, no accumulated equity, nothing that required negotiation or a mediator's intervention. It had ended the way things end, when they have already been emptied of everything that once gave them structure. He did not speak about Isabella, and I did not ask. What I knew from watching him across those Sunday afternoons was that he was not happy in the way happiness is sometimes described, easily, loudly, with the texture of something recovered. But he was honest, and honest was new, and I had learned enough in my 71 years to know that honesty is the ground that everything else has to be built on, and that it therefore has to come first, regardless of how unfinished it looks while it is standing alone. Isabella's criminal trial concluded in the spring. The jury deliberated for 2 days and returned convictions on 2 counts, forgery and investor fraud. Sentencing was scheduled for the following month. The civil suit brought by her former clients, whose documented losses had run into the millions across the fund's decline, was moving through its own separate process with its own timeline. She had not made a public statement at any point during or after the trial, which was, I supposed, the last professional instinct remaining to her, the understanding that there was nothing left to say that would not make things worse. Her name in the financial community was closed in the permanent way that names close when the conduct attached to them becomes a matter of public record. Not damaged, not diminished, closed. There is a difference, and the difference is finality. I thought about her less than I expected to. That is an honest thing to say, and I intend it honestly, not as a performance of magnanimity, but as a straightforward report of what I found when I looked for the preoccupation I anticipated and did not locate. What had happened had been set right. The mechanism that set it right had not been mine alone. It had been Margaret's and Patrick's, and the accumulated weight of documentation and law, and a 72-year-old woman who had kept a promise to her best friend across 9 years. I had been one instrument among several. That was enough. My days held their shape. I tended the garden through the spring and into the summer, and found, as I have found for 9 years, that the garden is the most honest, ongoing conversation I have. It responds to attention and neglects, neither to reward effort nor to register its absence. I had lunch with Patrick on Thursdays. I went to the cemetery on Margaret's birthday in August, which I have done every year since she died, and I talked to her for a while in the way I have come to talk to her, not performing grief, just reporting, telling her what had happened, telling her it had worked, telling her what I thought of the woman she had been, which was a great deal, and which I found after 9 years of practice I could say without the particular ache that used to accompany it, though the love underneath it was unchanged. Joanne joined me at the cemetery that year. We stood together for a while in the August heat, and I told her what I had been thinking, that Margaret would have been proud of Caleb, that the hard part he was doing now was the part that required the most of him, and that he was doing it without assistance from anyone, and without the comfort of knowing how it would turn out. Joanne looked at the headstone and said that Margaret would have been proud of me too. She said I had not become something I was not. She said it simply the way she says things that she means fully, and I received it the same way. Caleb appeared at my door on a Sunday afternoon in October unannounced, which by then was not unusual. What was different was that he was carrying groceries, 2 bags, the reusable kind, with the particular assortment of a person who has learned to cook for themselves and is applying that knowledge in someone else's kitchen. He did not explain it. He came in and set the bags on the counter and asked if he could make dinner. I told him he knew where everything was. We ate at the kitchen table. We talked about his work, about the garden, about a book I had been reading that he asked about with what appeared to be genuine curiosity. Before he left, he stood at the door and asked with the directness he had been slowly developing over the course of the year whether he could come by again next week. I considered it for a moment that was long enough to be honest rather than reflexive. Then I said yes. There is a particular quality to an October morning in Ohio that I have never been able to adequately describe to people who have not experienced it, though I have tried on occasion. It is not the cold exactly, because the cold in October has not yet committed to itself the way it will by December. It is the kind of cold that still carries the memory of warmth inside it, that sits at the edge of pleasant rather than past. Yet, the light is different too, lower and more amber, falling across the turning leaves at an angle that makes ordinary things look considered. I drove to the cemetery on a Tuesday morning in that light, with the windows down because the air was exactly the right temperature for windows down, and I parked on the narrow lane that runs along the eastern edge and walked the familiar path to where Margaret is. I have been coming here every year since she died, and in the years since the case concluded I have come, a few times more than that. Not from grief. Exactly, though, grief is always present in some form when you stand before a name carved in stone that belonged to a person you loved for 40 years. I come because I have things to tell her, and because I have found over 9 years of practice that telling her is not a performance or a comfort ritual but a genuine and necessary form of accounting. She was the person I thought things through with. The absence of that has not eliminated the need for it. I stood in the October light and told her what had happened in the order that it happened, the way I would have told her if she had been sitting across from me at the kitchen table with her coffee. I told her about the car conversation and the lawsuit and Patrick's work and the emails and the forgery in the courtroom. I told her about Joanne walking into Patrick's office with her canvas bag and the decision she had postponed for 9 years and finally stopped postponing. I told her about the clause, the document she had built quietly in a law office across the city with an attorney she had chosen specifically because the attorney had no connection to me on a Tuesday afternoon 7 years before any of this had happened. I told her it had worked. I told her everything she had designed for had come to pass exactly as she had understood it would, which was, I said aloud to the stone. And the October air, not a surprise to me at all, because she had always been the more precise thinker of the two of us, and I had known that from the first year of our marriage, and had considered it then and always one of the great advantages of my life. Then I told her the thing I had come specifically to say. I told her that what she had done, the decision to create that clause, the decision to tell no one, the decision to place it beyond the reach of my particular form of love for our son, was the most precise act of love I had ever witnessed. She had known, I said, that I would try to protect Caleb from the consequences of his own choices. She had known that this protection offered out of genuine love would have prevented him from arriving at the place he needed to arrive at. She had known that if I were warned, I would warn him, and if I warned him, the question of who he was would never be answered clearly enough for either of us to build on the answer. She had removed the option from me, not because she did not trust me, but because she trusted me, completely trusted me, to do exactly what she knew would not serve him, and she had loved both of us enough to work around that truth instead of asking me to be different from what I am. I stood with that for a while. The leaves moved. The light stayed amber and low. The relationship between Caleb and me is not what it was before any of this happened, and I do not expect it to become that, because what it was before was a relationship that had been quietly shaped by years of avoidance and managed distance and the accumulated weight of things neither of us had said. What we have now is smaller, in some ways, and more honest in all of them. We have dinner once a month, sometimes at my house and sometimes at a restaurant he has found that he thinks I might like, and these dinners are sometimes awkward and sometimes almost easy and sometimes simply two people who share 41 years of history sitting at a table together, which is its own kind of thing, and one I have come to value on its own terms, rather than measuring it against something it is not. He does not ask me for more than I can give. I do not require him to be further along than he is. We are both, I think, learning to be in each other's company without the architecture of expectation that used to organize the space between us, and it is slower work than either of us might have wished, but it is real work, which is the only kind that produces anything worth keeping. I walked back to the car when I had said what I came to say. The path was covered in leaves that had come down in the last few days, dry enough to move underfoot with the particular sound of October. I drove home on the route I always take through the residential streets rather than the highway, because I was not in a hurry, and the morning was too good to move through it faster than necessary. I made coffee when I got home. I sat at the kitchen table, the same chair, the house that Margaret had seen clearly enough to help me protect when I might have protected it too gently. I sat in the quiet that is my ordinary life, and found it, as I have found it for some time now, to be sufficient. Not empty, not a consolation. Sufficient in the way that a thing is sufficient when it is genuinely enough. Family is not inherited. It is chosen again and again, even when it costs something, even when the choosing is hard. Margaret knew that. She chose both of us long after she was gone. I suppose the least I can do is keep choosing for as long as I have left to do it. This story has stayed with me long after I finished reading it, and I think the reason is this. Leon never raised his voice, never begged, never chased anyone down to make them understand his worth. He simply knew who he was, protected what he had built, and waited with the patience of a man who understood that truth does not need to be loud to be powerful. If you take one thing from this story, let it be that. You do not owe anyone access to what you have earned. Generosity given freely is a gift. Generosity extracted through guilt or pressure is something else entirely, and you are allowed to know the difference. And if the people in your life mistake your kindness for weakness, let them. Because the moment they act on that assumption is the moment they hand you every advantage you need. Thank you for spending this time with me here on Revenge Room. If this story moved you, share it with someone who needs to hear it today.